Very good afternoon, friends. Another change in the GST portal in e-invoicing wide advisory issued yesterday on 20th of April, which would tremendously impact the supply chains of businesses. In this video, we will discuss what is this new advisory on e-invoices, what is the impact and how businesses, especially supply chains and finance and tax departments, should amend their procedures to implement this change, which would be effective from 1st of May 2023. So the advisory which was issued yesterday mandated from 1st of May 2023 that an e-invoice should be uploaded on the IRP not later than 7 days from the date of generation of the tax invoice. As of now, this would be applicable only for those taxpayers with an aggregate turnover, that is a pan-India turnover including the stock transfers of more than 100 crores. It would be applicable only to tax invoice type of documents in e-invoicing and would not be applicable to credit notes and debit notes. So let us understand the impact of this advisory by means of this example. Say on 31st of May 2023, you have generated a tax invoice. However, due to a technical glitch, the e-invoice on the IRP apropos this tax invoice could not be generated. Now when you go on to file your GSTR 1 for the period May 2023, on 11th of June 2023, you do a reconciliation between tax invoices and your e-invoices and you filed that for an invoice, the e-invoice was not generated. However, the time barring for generation of this e-invoice has already lapsed on 7th of June 2023. So what do you need to do now? You need to pass a credit note for the tax invoice earlier generated. Whether or not this would be an e-invoice credit note or a not e-invoice credit note, that needs to be checked on the IRP portal again. Now after this, you need to generate a new e-invoice on 11th of June 2023 vis-a-vis a new tax invoice on 11th of June 2023 and thereafter report it for the period June 23 in the GSTR 1 to be filed on 11th of July 2023. What would be the tax implications? Number one, there could be a general penalty invoked for non-compliance of GST law as per the invoice dated 31st of May 2023, right? Second, while the invoice was to be generated on 31st of May, you have generated it next due to this amendment on 11th of June. So there would be an interest implication under time of supply provisions and your recipient of the goods or services for this e-invoice would be able to take the input tax credit not in the month of May but in the month of June 2023. Therefore, he also might charge you interest or delay the payment against this invoice. So there would be a three-way ramification of this change. Hence, it is advised that taxpayers have to change their process within 7th of the next month, that is say for the month of May 2023, by 7th of June 2023, taxpayers need to do a reconciliation between their tax invoices as per their ERP systems and the e-invoice is generated. In case any e-invoice is not generated for any tax invoice, then it is required that by 7th you generate that e-invoice. Also during the month you need to do this check in regular intervals so that there is no non-compliance with the advisory. Also, it is our advice that even those taxpayers with an aggregate turnover of less than 100 crores, they should prepare for this change and implement it, because it is possible that this advisory would be implemented in phases, and going forward it would be applied even on the other taxpayers. Therefore, to prevent any disruption in your businesses, it is important that this advisory be pre-implemented as a matter of best practice. Thank you very much. Stay tuned. Do like, share this channel and this video for maximum dissemination of knowledge. Thank you very much.